So a lot has happened since the last time we talked. A lot of crazy stuff.
A lot. You've been busy as heck.
Yes. We had a 2-week, it was more 1 week murder trial so in Pensacola, Santa Rosa, Okaloosa, when there's going to be a trial, Monday is always the day we pick juries. So in all these different counties, what happens is Monday, potential jurors show up, and it doesn't matter what kind of case you got. You know, DUIs, murders, car accidents, Monday's the day you pick, always. Other places, Miami, Orlando, you can pick on any given day. You can pick on a Wednesday, you could pick on a Thursday, whatever. Okay, but here in our area, we only pick on Mondays. So that murder trial was so big, the Friday before we picked the jury, so Friday, Saturday, Sunday, we're picking the jury on Monday, we're taking depositions of expert witnesses for like major testimony. That's how big the trial was, is we were still getting ready to have the trial. I mean, really, I thought that we were going to have to take depositions. I thought we were going to have to depose essentially brand new witnesses during the trial. And for a big case like that, that's unheard of. That's crazy.
When you pick a jury, can it start same day?
Yeah, absolutely. We call that a pick and go. Normally it doesn't, because on the criminal side, what you got to imagine is we try more cases on the criminal side than they ever do on the civil side. I mean, it's like 100 to 1. I'm being serious. So every Monday, if a particular judge on the criminal side is picking juries, they're normally picking more than one case. Okay, so we'll spend all day long picking 2 to 3, 4 cases. And because of that, we can't start that day. So like, let's say I was the first one to pick. I pick my jury. Then the next people up, they pick their jury. So the judge doesn't know how long it's going to take, and my case can't start until all that's resolved. So normally on the criminal side, we don't do pick and goes, but on the civil side, because they don't have that many trials, when they're going to pick a jury, normally they're the only ones picking. So they can pick that jury and then immediately begin. But like I said, I mean, 100 to 1, maybe even more, is the amount of criminal trials we have versus civil trials. You know, and I've tried both cases. I've tried 100+ criminal cases easily. I can't give you the exact number, but we're in the hundreds. And I've tried civil cases. And the interesting thing about criminal cases, and I am 100% positive on this at this point after my last murder trial. That was the 5th murder trial I've had, and that was it was a big case. When jurors show up, when everyday citizens who are called for jury duty, when they show up for their jury service and it's a criminal case, even if it's a nasty case, like even if it's a murder case or a case involving children, they will try to do their best to be a good juror, because in their mind, it's like a civic duty. You know what I'm saying? It's like this, that is what they were taught from a child, that the jury system's about. That's what they see on TV, Law and Order and yada yada. So on the criminal side, they have this almost like a calling to try to do their best, because they think it's part of our society. It's a framework, the fabric. It's part of their duty. On the civil side, they're much more lackadaisical. And I'm not saying they don't do a good job or they don't care, but the urgency, the focus, I can see it a lot more on the criminal side than I do on the civil side. On the criminal side, it's like they understand that this is high stakes. Where on the civil side, they're like, well, this is only about money.
So a friend of mine just got selected, right?
Yeah.
And it must have been a sit and go because it was same day. There was no alternates.
Nah.
Somebody got sick, and it was over.
Yeah, so I think that case was a federal case.
Okay.
So on the federal side, the amount of cases that they actually have open is like this.
Okay.
Okay. On the state side, down state court, we got hundreds upon hundreds upon hundreds of cases. The feds, they deal with very little cases. So they can do things like that. They can set, okay, this date, we're going to set this one case, we're going to pick the case, and then we're going to roll with the trial. They can do it. So before COVID, the times that I would ever see us using alternates, what happens is when the jury's selected, the alternates don't know they're alternates, right? Like we don't tell them, hey, you're an alternate and you're an alternate. They don't know.
They're placebos.
Yeah, exactly. So before COVID, the amount of times that we would either have to use an alternate or kill a case, mistry a case because something happened, were like 1 out of 1,000, maybe 1 out of 50,000. You would never see it. You know, we would have the trial, and at the end of the trial, juror number so-and-so misses, juror number so-and-so misses, blah, blah, blah. You guys are the alternates. And a lot of times, the alternates would be upset that they are alternates.
Sure.
Because they just sat through, how many days of a trial, and they're like, well, now I'm an alternate? So the alternates, the times that we would ever use them would be never. And a lot of times when you're picking that alternate, you're not as cautious because there's just a belief that, man, we're never going to use this person. The crazy thing is a lot of times at the end of the case, when the alternates find out they're alternates, they want to get out of there. They're like, okay, if I'm not doing anything, I'm out. The crazy part is when they want to stay. That's what gives me the real chills. Because that's when I'm looking at them like, dude, I really messed up picking you if you want to stay. That scares me badly. Scares me a lot. Jury selection. So this murder case that we had 3 weeks ago, it's a big case. I mean, it's one of the biggest murder cases that we've had in our county in years. It was a 20-year-old cold case, tons of witnesses, tons of evidence. When you're picking a jury, that's 3 to 4 hours of questioning roughly 60 people, okay? You have a list. It's more like a seating chart that has essentially 12 people per row, and every person's like a little box. And by little box, I mean like this big, little box, okay? So you'll have their name and their juror number, and then the next box, same thing, right? But when you're questioning them, and we're talking, talking to these people for 3 to 4 hours. And the whole point is to get to know these people so well that you can make a decision of whether they're going to be a good juror for your client, right? Trying to do that in 3 or 4 hours is impossible. Like how many times have you met somebody, hung out with them for hours, and then weeks later you're like, I saw a side of that person that I had no idea. Or the guy ends up being a lunatic. I mean, we talked about this, you know what I'm saying? So it's very difficult to do. But in that little box, what I'm supposed to do is write down every response to all these questions. And we're talking hundreds of questions that's relevant to make the decision. Well, what happens is sometimes you miss it. Like here's an example. In cases involving violent crimes, one of the almost guaranteed questions that the prosecutor is going to ask is who has had family members, friends, or people they're close to that have been victims of a crime. Okay, and you'll have all kinds of responses. We've had people say, my son was murdered, or I was burglarized, or whatever. Okay, those are important questions for me because I don't want to put someone in a jury, have them hear some facts, and then their mind starts rolling back to what happened to them. Or what happened, and that's what their focus is. Okay, once that happens, you can't pull it out. So anyway, in this big murder trial we probably had out of 60 people, maybe 30 to 35 people say that they had some connection to somebody who was a victim of a crime. Okay, and that question is asked at one time. All right, it's not asked individually.
Yeah,
okay?
yeah.
So what I'm supposed to do when these 35 people are responding is I'm supposed to, as quickly as possible, identify them, which when you're talking 4 or 5 rows back and they're in the middle, you don't know if that's Mr. Garcia or Mrs. So-and-so. You're trying to count as quickly as you can. But anyway, what happens is you may not get 100% of their responses. And sometimes somebody will land on the jury because you just didn't have it marked down what their response was to a question 2 hours ago. That happens all the time. All the time. I mean, it's so difficult, the process. It's such a crazy process. Really, it's like trying the case. I'm not going to say it's easy, but it sure as hell is easier than picking the jury. All right. I mean, I kind of know what the witnesses are going to say. And when you do this long enough, the juices, man, that the energy flows in trial. Like, honestly, preparing for a case, I used to like go through every word and every file. Now, I don't get the energy until I'm there. That's when it starts kicking in. So when you're picking the jury, it's the hardest thing we do, and it's crazy that we don't have a better system.
As being in a jury selection, I think myself and a lot of other jurors in that room wonder what you guys are going to talk to the judge about.
Absolutely. Yeah.
Because it's both attorneys and or attorneys, plaintiffs, defendants, whoever it is. And then
it's everybody.
Sometimes they're laughing and then they're looking at us like, are they making fun of us? I know they're making a decision about jury, sure, right? But
I mean, what we're essentially doing is picking the jury by striking people out. That's how it really works, right? It's not like we say, I want that person in. It's who you're left with after you kick certain people out. But what I'm getting to is, nowadays there's so much technology. This is one of the first trials that at the same time we're picking, we're looking through Facebook. There's so much technology that can give us so much more understanding of the person rather than me just for an hour asking, not random, but questions that people don't. No one sits around the dinner table and say, let's talk about times that we were victimized, or let's talk about people we know who've been robbed. No one says that. So it's a lot. Sometimes you get jurors as a group who are very quiet, like they don't want to talk. Who knows why? I mean, maybe they were down there at jury assembly for hours and they got tired. Who knows? But that happens sometimes, and you're literally just trying to pull every bit of information out of these people, and you don't want to say, hey, Mr. So-and-so, my client's looking at life in prison. Can you just answer the effing question? You can't do that because you're trying to put on a good show. You know what I'm saying? So sometimes it gets crazy. I mean, I remember when I first started doing this, like I said, hardest thing, picking a jury, absolutely. I remember I would almost get into arguments with these people. Like I would get aggressive towards them. Like, just answer the question. Yes or no. Do you hate me and my client? That's all I need to know. Now I'm very, very good at it. But when I first started, oh God, it was horrendous. Horrendous.
I really did get the feeling of everybody that I met, to their own sense, was starting from scratch for that specific scenario, right? So, I mean, literally somebody just jump out and go, hey, what am I stopping you from doing today? And I'm just like, golfing? Everyone starts laughing. I'm like, why is this guy asking this question? He's trying to read me. He's trying to figure out, But I've seen people use all the floor space, try to be funny, or whatever they can do to relate. It's fun. It's fun for me to watch their different angles and tactics to try to. And beyond a reasonable doubt is used probably 20 times every time I'm there.
Yeah, for a criminal case, that is like the basic thing that you're taught is on the defense side, literally say reasonable doubt as many times as you can. The interesting thing about reasonable doubt, and the reason that it's talked about so much, is no one knows what it is. Like, I can tell you what a red light is, boom, it pops up in your head. I can tell you what certain aspects of testifying are, but no one knows. Like, here's a great example. If I say this is a DUI case, do I need to tell you what the legal elements of a DUI are? Probably not. You're going to think, okay, well, to be DUI, you got to be driving or doing something in a car. You got to be wasted. And, you got to be wasted to the point that it ain't good, right? I mean, we don't need to give you section so-and-so, so-and-so, the legal definition. But when we're talking about reasonable doubt and you're talking to 100 different people, you literally get 100 different responses. And the way that our reasonable doubt is defined in this state, the actual instruction basically says a reasonable doubt is not all this stuff. It doesn't tell you what it is. It just tells you what it's not. In the words that is used in the instructions, it's if you have an abiding conviction of guilt, then you should find the person guilty. If you do not have an abiding conviction of guilt, if it's one that wavers and vacillates, then the charge is not proven and you should find the person not guilty. So when I'm picking a jury, what I normally tell to the jurors is, hey, listen, when lawyers get together and we're asked to write some things up, do y'all understand that we use way too complicated words and we make it way too long? And they would normally get a little chuckle. I say, okay, that's exactly what the reasonable doubt law is. It's a bunch of complicated, convoluted words trying to describe something that it's like pixie dust, man. It's like this stuff out there in the ether. So what I tell them is, listen, have you guys ever used the term abiding conviction? Have you ever gone to a friend and said, you know what? I got an abiding conviction to go to Sonny's today. And get a little chuckle. No, we've never had that happen. I say, well, that's exactly it. We're using these words that no one uses in normal speech, but there is a word that we use in normal speech that means a super high level of belief, and that word's faith. I would say if you have an abiding conviction in something, you have faith in it. And that is the level of belief that I would say you would have to find someone guilty. You have to have faith that they did what's being proven. So I try to wrap it in that. And man, I have some judges who freak out because I'm using the term faith, as like a religious tenement.
That's subjective.
Yeah, sure. I tell judges, look, bring in a Yankee fan. I'm sure they have faith that the Yankees are going to win. Doesn't mean it's religious belief,
yeah.
But the reasonable doubt, the reason it's talked about so much, and in the end, it's because no one can really describe exactly what it is. That's one of the big weird things about criminal law. Where on the other side, civil stuff, everything's pretty well defined. I mean, you could figure it out pretty well as you go along. It's not this kind of weird ether, whether it's there or whether it's not.
So that's why they just pile drive it during jury selection.
Absolutely.
So everybody understands once you're selected that it's there. Reasonable doubt is just constantly going through the brain. The
idea is reasonable doubt is such a high standard. It's such a hard thing to hit that the state ain't going to hit it on every case, even if the person actually did what they're accused of. It's just so high, they ain't batting 100, right? That's what you want. But to be honest with you, that standard, even though it's so high, it changes per case. So if you have a case involving a child or an animal, an animal abuse case, reasonable doubt is really low. They are starting on the side of your person's guilty. Prove me otherwise. Instead of the opposite where it's prove me this guy did what you're saying he did. So sometimes it depends on the case. Sometimes that reasonable doubt standard on certain cases doesn't even matter. The jurors are not going to follow it.
So it's like a game of guess who mixed with chess?
It's a game of speed dating. This is really what it's like. It's like speed dating with a little bit of gut intuition, a little bit of Columbo, maybe I get it right, maybe I don't. And then on top of that, a game of words. Because let's say I'm talking to a juror and I say, hey, this reasonable doubt thing, you understand, super high, it's the faith. People say that we would better have 9 guilty people go free versus 1 innocent person found guilty. You understand that? Some people will say, look, I understand it. I'm not down for it. I think the system has now gotten too crazy, and I think people who are guilty go free all the time. And, I don't know if I could follow that reasonable doubt. You'd say, okay, I appreciate that, right? To me, that means this person ain't a perfect juror. I'm looking for perfect jurors. Okay, this person's someone that I'm going to X out. Okay, it's not because they're a bad person. That's just their belief. I don't care where it comes from, whatever. But if the judge says, ma'am, here's the actual law. What I did, the whole abiding conviction. Here's what the law says. Can you follow the law? Do you know how many people will say, oh, I can follow the law? 100% of them. Not one person's going to say, Judge, you know what? F you and F that law. law. No, every single one of them is going to say, well, Judge, if that's the law and you read it to me, yeah, I can follow it. So then you get into these arguments with the court about what was the special words used by the juror. So it's crazy. So you have to be very calculating in the kind of questions and how you frame them and try to like walk jurors into a certain response.
Yeah, check this out. Somebody asked my room if anybody in the room had ever smoked marijuana.
Right.
I mean, the wave of silence that came over the room.
Exactly.
And the response from the judge, from everybody, was so comical because we felt like we were incriminating ourselves if we said yes. It was the weirdest situation I've been in inside of a courthouse. It's crazy. Because everybody in the room was like, whoa, hey, we're not being deposed here.
Yeah. Slow your roll.
Yeah.
I had this was many, many years ago. So I had a jury selection in a big case, a capital sexual battery case. Big case. This may have been one of my last cases that I was working with the state on. And the dude right after me was some lawyer I've never seen before in my life from like Chipley, Florida. Small town Florida, right? So his guy was charged with a really serious DUI where I think some people were really hurt. And before he goes up to pick the jury, he's trying to get the guy to plea. Like almost screaming at his client, you need to plea. That's not a good look. You know what I'm saying? At the end of the day.
For the jurors?
Yeah. Because I had just picked. So then he gets up there and you can kind of tell like he's already upset that he has to go up there and pick the jury. The second question he asks is, who here thinks that they may have some racist tendencies? Do you think anybody was like, oh, right here? Well, thank God you asked that question. It was like people were looking around like, are you effing kidding me? It was crazy. So there are questions that you ain't going to ask them. The whole marijuana thing, I'm looking to see if, look, no offense, but if you were in the jury, I'd be like, oh yeah, that guy. don't need to ask. Keep that one in the pocket. The 80-year-old person who goes, oh, Baptist church. I'm not asking her, ma'am, have you ever smoked marijuana before? You know what I'm saying?
Yes.
So the first case I've ever tried in my life, this is when I became a lawyer. I don't know anything about what's going on, was a marijuana case. First case I ever tried. Dude is caught smoking weed, like literally caught smoking weed in the middle of this park over in Montclair. And the cops walk up as he's smoking out of a pipe and he has weed in his pocket. So we pick the jury and the prosecutor asked that question, who here's smoked marijuana? No one raises their hand. No one says a word, right? And look, the average age of jurors in our area is about 55. They're more on the older side, okay? So you had a lot of older people who were in this jury. One of them, I can picture the guy to this day. He was like this older engineer who, honestly, if you looked at him, you wouldn't think that he ever smoked marijuana. But who knows? He could have been in Berkeley back in the 70s when he's going to his engineering school, okay? So we're having the trial. Honestly, the case was a waste of time because clearly the dude had marijuana. That was the question. Question answered. You know what I'm saying? So the state has this little envelope that had the little bud of marijuana in it, and they're showing the jurors, person by person, the marijuana. Okay, it's about like this big. Okay, and it's in the back of this envelope. Okay, so normally what the jurors would do is they would just kind of look at it and wouldn't care. Okay, whatever. They've heard the testimony from the officer. They're not disbelieving it's marijuana. But when they get to that guy who's in his 50s, the engineer, dressed up in a button-down shirt, slacks, he's sitting on the very end, he grabs the envelope, starts like putting his nose into it. It's like, it's like, oh yeah.
It's legit.
Definitely the marijuana.
This is California.
Exactly. And I'm looking at this guy like, you SOB. Yeah.